Good afternoon, everybody, and thank you for joining us today for our author talk with Dr. Jude Pfister. My name is Andrew Daphne. I'm the Instruction and Outreach Librarian at the New Jersey State Library. And before I turn it over to Cindy, who always does a wonderful job with her author introductions, I just want to go over a brief housekeeping item with you, and that's going to be namely the GoToWebinar dashboard. For those of you who might not be familiar with it, this is what your dashboard should look like. If you don't see it, look for this orange box with a white arrow, either at the top left or right-hand side of your screen. That will open and close the dashboard, and it's possible that the dashboard loaded closed on you, or if you were on your device working in another program, look for this GoToWebinar icon. It kind of looks like a blue clover at the bottom of your computer screen, and if you click on that, then that should bring up the GoToWebinar dashboard as well as the screen that's being shared. At any point during the program, if you have any questions, can't figure out what to do, and want to get in contact with me, you can use this raise hand button here. Just click on that. I'll get an alert and I will be in contact with you and hopefully be able to resolve your problem. We will be taking questions at the end of the program today, but you can submit them at any time using this questions box down here. So please just type in your question, hit send, that'll get sent to us, and we'd be happy to answer that for you at the end of the program. So, that's everything I have. So I'll turn it back to Cindy now, who will do the introduction.
Hi, everybody. I hope you're enjoying this day, and I hope you enjoy this talk. I think we've got a great topic for you, and I'm just happy that you can be with us today for this virtual author talk hosted by the State Library. Remember that our website lists all the virtual programs available, and so coming up on October 14th, we have one that's from noon to 2 p.m., and it's a virtual genealogy panel discussion. There's 5 panelists who work in a variety of professional capacities will be available to answer your questions. And you can register for that online through our website. So I think that's going to be a real interesting webinar or virtual panelist discussion. That'll be great about different areas of genealogy. Our next virtual author talk is going to be on November 4th. And we'll be looking at Woodrow Wilson, Commander-in-Chief, with Michael Ricards. So I hope you can join us for that talk. Today, we have Dr. Jude M. Pfister, and he'll be telling us about the creation of American law and the creation of the 1790 Supreme Court. Dr. Pfister has been with the National Park Service in the field of historic preservation and cultural resource conservation since 1993. A historian by training, he has experience in a variety of settings impacting many of the most historic sites in the United States. Currently, he's also the Chief of Cultural Resources, Morristown National Historical Park. This book is his 6th book written about national or New Jersey history. So let's welcome him in. Dr. Pfister, welcome today, and we look forward to what you have for us as a speaker.
Okay, thank you very much, Cindy. Let me just get this up and running, and then we'll be set. Okay. So again, good afternoon, everyone, and thank you for joining us on this lovely fall day. And before I begin, I want to formally thank Cindy Warwick and the New Jersey State Library and Cindy's team, especially Andrew, for handling the technical aspects of this and putting together everything that needs to be done for a presentation like this. And before I begin, I just want to say 2020 marks the 230th anniversary of the first meeting of the Supreme Court, which occurred in 1790. So I just want to point that out. It didn't get much press, but that's the way it goes sometimes. So here let's begin. Article 3 of the United States Constitution called for a Supreme Court and other inferior courts as Congress saw fit to establish. The inferior courts involved district and circuit courts. Naturally, these have grown over the last 2 centuries and now include a myriad of other courts too numerous to follow. So today we're going to deal with just these 3 that I'll be talking about. The Supreme Court, these are all on the federal level. The Supreme Court, the district courts, and the 3 circuit courts. Now, once the federal government began operations in the spring of 1789 under the new Constitution, the Senate immediately set to work drafting the legislation to create the federal judiciary. And this legislation was called the Judiciary Act. Senators Oliver Ellsworth of Connecticut and our own William Paterson of New Jersey, here's his university, Ellsworth and Paterson, both future Supreme Court justices, were responsible for drafting the legislation and for leading the ensuing debates. It's not entirely clear why Ellsworth and Paterson were chosen for this role. It was probably just the way the duties fell in the Senate. However, it's nice to say that the legal system we have today is the result, in part, for good or bad, of a New Jerseyan. Now, the battle over the Judiciary Act in the Senate raged for months during 1789 over the summer, with many senators bitterly complaining over the proposed power of the federal judiciary. And in certain ways, the arguments of 1789 were a rehash of similar debates that occurred at the Constitutional Convention in Philadelphia in 1787 over the same topic, just 2 years prior. As an example, at one point, there was serious discussion of having the highest state courts serve as district and circuit courts, which would have amounted to the inferior courts on the federal level. And again, this was first brought up at the Constitutional Convention in 1787, and then in 1789 it was reintroduced. And the idea was to provide or to attempt to ensure some aspect of state sovereignty within the judicial branch. Again, the judicial branch is one of three called for in the Constitution. There's the executive, the legislative, and the judicial. So here you see just the three districts, the eastern, middle, and southern, along with the, excuse me, those are the three circuits. There were three circuits at that time, and then the other districts and so forth. So the Judiciary Act, as it came to be passed, this is just a screenshot that I found online. It's impossible to read, so don't try. It was a dense document, I think you can see, and it was also a rather large document. It was full of arcane lawyer language that satisfied almost no one, except President Washington. Not because he understood arcane lawyer language, he didn't. He was, however, eager to get the government up and running with all three branches functioning. He saw the Judiciary Act as a means to an end. So the legislative and the executive branch started operating in the spring of 1789, and then it was up to Congress, the legislative branch, to bring into being the federal judiciary, which is the third branch. So, excuse me, and again, this was critical for Washington. He saw this as absolutely necessary for the government and for the young nation. And again, the Judiciary Act of 1789 really was a very obtuse piece of legislation. John Dickinson called it one of the worst pieces of legislation he ever had the opportunity to read. However, it was in place and it was functioning. Now, on September 24th, 1789, the same day that Washington signed the Judiciary Act into law, and almost exactly 2 years after the Constitution was signed in 1787 in September, President Washington nominated 6 jurists to seats on the newly created Supreme Court of the United States. You can see in this, it's not the best image, but nonetheless, this is the document that Washington sent to the Senate for their consideration. And you can see some of the names there. You can see Washington signed it at the bottom. Now, in addition to this, Washington also personally wrote each appointee appealing to their judicial wisdom, sense of patriotism, and devotion to the public good. In each letter that he wrote to the appointees, Washington commented on the importance of the judicial branch. Whether this was from personal conviction about the place of law in society, or whether he was trying to inflate the role and sell the appointment is difficult to say. The answer is probably somewhere in the middle, because again, any delay in staffing the court would not only be embarrassing, but unnecessarily time-consuming in relation to the overall need to ensure the machinery, the infrastructure of the Constitution was functioning. Again, for President Washington, there was a sense of urgency. Without question, the major focus for the president was to get the government running. Furthermore, Washington was aware or anticipated the respect and the role which the Supreme Court should, and he thought would, have in the new nation, which was why he was so concerned about what we would today call the visuals of having all three branches up and running. And just looking ahead a little bit, the Supreme Court, particularly the personnel, would dog Washington through both of his terms. Now, in his brief note to the Senate, Washington nominated John Jay of New York as Chief Justice, and James Wilson of Pennsylvania, John Rutledge of South Carolina, William Cushing of Massachusetts, Robert Harrison of Maryland, and John Blair of Virginia as Associate Justices. All were eminently qualified. The original 6 appointees, Jay, Cushing, Rutledge, Blair, Wilson, and Harrison, Iredell, I'll get to Iredell in a few minutes, were all men personally acquainted to greater or lesser extent with Washington. All were nominated and duly appointed with the exception of Robert Harrison, who became the first nominee to refuse his nomination, and he cited ill health. Now, Harrison wrote to Washington, quote, "On no occasion of my life have I been under an embarrassment so painful. It is at length with a difficulty almost inconceivable, after revolving every circumstance, and after many days and nights of anxious solicitude, that I have come to a final determination that I cannot but decline the appointment." Harrison continued that, "As a judge, solicitous to discharge my trust, I must hazard in an eminent degree the loss of my health and sacrifice a very large portion of my private and domestic happiness." Now, aside from his personal health, and Harrison was clearly onto something here, Washington knew he was ill. He had no business appointing him. Harrison would be dead in less than a year. Harrison noted the physical vigor in addition to the intellectual vigor that was necessary to be a justice riding on circuit. Justices at that time, just like they do today, were appointed to one of those 3 circuits. Obviously, today there are more circuits, but current Supreme Court justices are assigned to circuits. Of course, they don't ride them today as they did in 1790. So this was the first instance by Harrison, and by no means the last, of the issue of circuit riding. And by circuit riding, it means just what it sounds like. They went out on their horse or their buggy or boat and traveled around the country to these circuits. And I don't need to tell you that the transportation system during the first decade of the Supreme Court throughout the United States was not the most inviting. Now, so again, Harrison's mention of this circuit riding was not the first instance, and by no means the last, of circuit riding putting a nominee off accepting appointment to the court. And just before we get off of Harrison, I just want to say that at various times, he was an aide to Washington during most of the Revolution, which is how Washington knew him. Harrison also served at various times as an attorney for General Washington. And in the winter encampment in 1779-1780 at the Ford Mansion in Morristown, where I work, Harrison was there for that 6 months. And during that time, Washington was being sued in a case in Virginia as the last surviving executor of the last will and testament of a neighbor. And so Washington, even though he was commander in chief, still had to respond to this civil suit. And Harrison was his acting attorney at that time. And this is a wonderful, it's about a 17-page response that Harrison wrote out. And for Washington, you can see Washington signed it there. This is in our collection at the park. So anyways, that's really how Washington and Harrison got to know one another. But in Harrison's place, Washington nominated James Iredell of North Carolina. And in an effort to share his personal view, President Washington wrote to the first justices as a group. I mentioned that Washington wrote to each one individually, but he wrote to the justices as the Supreme Court assembled in 1790, 230 years ago, as I mentioned, as they were preparing for their first meeting. And Washington wrote, quote, "I have always been persuaded that the stability and success of the national government, and consequently the happiness of the people of the United States, would depend on a considerable degree on the interpretations and execution of its law." Many in the public were watching the list of nominees that submitted by President Washington. And one observer was Abigail Adams, the wife of Vice President John Adams. Abigail Adams was well known for her interests in government, and as a letter from 1789 to her sister, Elizabeth Smith Shaw, indicates, she was following events closely. On September 27th, just 3 days after Washington nominated his choices to the Senate, Abigail Adams wrote, "I am fearful of touching upon political subjects, yet perhaps there is no person who feels more interested in them. And upon this occasion, I may congratulate my country upon the late judicial appointments, in which an assemblage of the greatest talents and abilities are united, which any country can boast of. Gentlemen in whom the public have great confidence in support of our government." And just as a side note, John Adams was briefly considered for Chief Justice, but we know that did not happen. Now, President Washington took great care in nominating individuals whom he felt represented the best that the American legal system had to offer. Not trained in the law himself, unlike John Adams, this created some problems for Washington, but Washington nonetheless understood the importance of the unique quality law played within any society. His nominations, whether confirmed or not, were designed to ensure a public looking to enhance the stability of the new government. Now, at first glance, the 13 men, and I want to talk just briefly about all 13 men who were appointed in the 1790s by Washington and Adams. And so again, there were 13, and yes, at that time, they were all men. So to look at those 13 individuals appointed to the Supreme Court by Presidents Washington and Adams between 1789 and 1800, all seem to be kind of cut from the same mold. And besides the 6 original appointees, there would be, and these next several are by Washington, there would be Thomas Johnson, our own William Paterson, as I mentioned, Samuel Chase, who was one of the most problematic, and then Oliver Ellsworth. And John Adams would nominate Alfred Moore of North Carolina and Bushrod Washington of Virginia, who was George Washington's nephew. And of course, for those who are wondering, it was John Adams who also appointed John Marshall in 1801, but that's just a little bit out of our time frame here. I'm trying to have this be a John Marshall free Supreme Court talk. Now, all of these men, they were white, male, obviously highly educated, Protestant, American gentry, if not aristocracy. The list could go on concerning their similarities. Yet just below the surface, some differences are perceptible. Still, while those differences are what makes each man individual, the similarities account for the sense of cohesiveness they brought to the court. In total, every nominee was a founding father. Some were more involved than others, but each one had contributed to the founding of the new nation. This was an important component for the early leaders in the 1790s. In fact, President Washington wrote that, quote, "In appointing persons to office, and more especially in the judicial department, my views have been much guided by those characters who have been conspicuous in their country." Now, all were leaders in their home states. All were considered to be of the highest character, except Samuel Chase. 6 had served in the Continental Congress. Chase, Ellsworth, Rutledge, Blair, Patterson, and Wilson. 2 signed the Declaration of Independence, Wilson and Chase. 4 signed the Constitution, Blair, Wilson, Patterson, and Rutledge. And 1 was one of only 6 men to sign both the Declaration and the Constitution, and that was James Wilson. Now, it is critical today to know these figures because most of what we read, hear, or learn about, particularly the first decade, is void of any reference to their humanity. We forget these were living, breathing human beings just like us. We tend to sense the black robe, and yes, they wore them in the beginning, just like today, although in the 1790s, some justices wore distinctively English-inspired robes and wigs. Some of these robes had fur trim, and some of them had quite bold colors, as you can see from John Jay's robe. And we see that, and we instinctively withdraw or suspend perhaps our critique of them as people, because the robe has a certain impression of majesty about it, much like a religious figure in vestments of some sort. The robe is meant to announce to those who observe it that they should maintain a certain amount of awe, to cease questioning perhaps, to respect the wearer and his announcements. Unless we can get beyond undue reverence concerning the early republic, and I'm really looking at the first decade here, these justices are doomed to eternal obscurity. And talking about obscurity, I'm just curious, in 2007, PBS put together a documentary on the Supreme Court, a 2-hour program that was meant to introduce to the American people the Supreme Court. And unfortunately, as far as I'm concerned, they spent less than 5 minutes talking about the first decade of the court. So again, when I say obscurity, I'm not just providing my own opinion there. Even PBS, I think, kind of lost on that one. But anyways, as is the case throughout American history, the early justices were devoted to the well-being of the United States and of the stability of the Constitution as the foundation of American life. These 13 men during the 1790s were not only guiding the young republic through that decade, they were guiding the future republic as well. Their backgrounds prepared them to see America as not only in the moment, but in the becoming. And America perhaps constantly unfolding and pressing ahead into the future of some not unknown path, but a path articulated by a document, the Constitution, of which they were the arbiters. In total, the Supreme Court would adjudicate as arbiters just 61 cases before 1801. And it is worth pointing out that the Constitution itself is a unique concept. We toss it around today as though it was a foregone conclusion during the founding period, but nothing could be further from the truth. A written constitution was a novel idea in the British legal world, of which America was a descendant. And Britain, I should point out, as most probably know, did not and still does not have a written constitution. George Washington was a president of many firsts. Of course, everything he did as president was a first for a president, except, I think most people know, live in the White House. He was not the first president to live in the White House. Now, as such, this list of firsts contain contains Washington being the first president to be solicited by office seekers. In particular, for our story, job seekers for the judiciary posts. On August 30th, 1789, Georgia governor, who was a signer of the Declaration and a member of the Continental Congress, Georgia Governor George Walton, wrote to President Washington that although he had been, quote, employed in the service of America, almost without interruption, since the commencement of public meetings and discussions which led to the Revolution, I do not recollect ever to have solicited an appointment. Walton continued, that it had been suggested that my desire of serving in the judiciary of the Union might be doubted at New York. And what he meant by that was that New York at that time was the capital, and that's where Congress was meeting. And Walton felt that some of his colleagues felt he didn't want to have a job, to have a position as a judge in the federal government. Walton was not interested in the Supreme Court. He was interested actually in the district court of Georgia. He didn't want to travel all the way to New York. So again, Walton was interested in the position of a judge in the district of Georgia. And he met every one of the president's criteria, yet he was not appointed. However, in kind of a strange twist of history, he was elected senator from Georgia and still ended up going to New York as senator. The Senate, of course, in those days was a senator in those days was elected by the state legislature. So he ended up nonetheless having to travel all the way to New York. Now, in the president's home state of Virginia, Meriwether Smith sought to approach Washington about employment. He wrote, quote, "Permit me to interrupt you for a moment in soliciting a favor for myself," Smith began. As with Governor Walton, Smith saw himself as a supporter of the Revolution from the beginning. Now, in his declining years, he sought a suitable government post. Smith continued, "I make an application to you, President, for some honorable and lucrative employment under the government, suitable to my declining years, which, by the casualties to which my fortune and family have been exposed under the Revolution, would be highly acceptable and convenient to me." Smith, like Governor Walton, sought a position in the judiciary, not on the Supreme Court, but on the district. And Smith, again, like Governor Walton, received no appointment. Now, like many later presidents, Washington sought to geographically balance court membership. There were many good reasons for this. Rough balance would ensure the composition of the court would not unduly favor one section or state unfairly. It also ensured that the justices would share in both long and short rides to their circuit courts, thus ensuring relatively equal shares of discomfort during the arduous circuit court duty. Now, I've mentioned several times about personnel issues, and I'm going to just use John Rutledge as the example of this. The circumstances surrounding the two separate appointments of John Rutledge to the Supreme Court, I think, caused President Washington the most stress in terms of personnel matters. Rutledge had lobbied the president for the Chief Justice position from the start in 1789. When that position went to John Jay, Washington made Rutledge feel a little bit better by saying he was appointed to the position of Senior Associate Justice. Now, there's no such thing as formally as the Senior Associate Justice. That position still exists informally, but it's held by the justice who has the longest tenure on the court. So, so this is 1789. Now, 5 years later, after the resignation of Chief Justice John Jay, who had left to negotiate the Jay Treaty, and then when he returned from England, he found out that he was elected governor of New York, so he resigned. Rutledge again reached out to President Washington. Now, what had happened in those 5 years, John Rutledge had actually resigned from the Supreme Court in 1791 to become the Chief Justice of his home state of South Carolina. And this time, the president, we're into 1795 now. It's getting to be the last year of Washington's term. I think Washington was pretty tired by this point. This time, President Washington was more inclined to nominate John Rutledge as the chief. However, the issue was that Rutledge's mental health had been progressively getting worse. And the second issue occurred when Rutledge publicly spoke out against the Jay Treaty in 1795, angering Federalists, including President Washington. Now, Washington over the summer used his prerogative of appointing Rutledge as a recess appointment to the Supreme Court. So Rutledge actually sat as Chief Justice during the summer of 1795 and into the fall. When Rutledge's nomination was brought up before the Senate, it was soundly rejected. And Rutledge, on the day after Christmas in 1795, tried to kill himself by jumping into the harbor in Charleston. He would end up being rescued by two enslaved Africans. These two gentlemen were not his personal slaves, but yet they were some that just happened to be nearby. They rescued Rutledge, and Rutledge really spent the last 4 years of his life as a recluse, alternating between lucid moments and periods of insanity, and lived alone, aside from his slaves and servants, in his home in Charleston, which you can see here. And as of the last I remember reading about it, it's a bed and breakfast now, so you can probably stay at the John Rutledge home. But nonetheless, it was a really sad story, and it just kind of encapsulates some of the issues that Washington had with nominating justices. Now, the most significant case for the Supreme Court during the first decade happened within the first 2 years. And although not a case in a strict sense, Hayburn's case represented a milestone for the court in the establishment of boundaries. The justices had been tasked by the 1792 Invalid Pensions Act to take statements from veterans or their widows and orphans. The statements, per the act, were to be reviewed by the Secretary of War. Now, this came out while the justices were on circuit, so they were not meeting as a group. And each one responded to this in a negative way. They all found this extrajudicial duty to be beyond the constitutional limits of their official work, especially given the fact that a member of the executive branch, the Secretary of War, was to review their work. They found this to be incompatible with the Supreme Court as a separate separate and equal branch of the government. Now, during the time that Washington was president and Adams was president, the Supreme Court was plagued with domestic and international crises. There was the Whiskey Rebellion, the Jay Treaty that I mentioned, the quasi-war with France, these being some of the most protracted crises, and all of these topics involved the Supreme Court in one way or the other. In fact, the justices were asked to comment, again, very much like Hayburn's case in 1792, they were asked to comment in an extrajudicial manner by President Washington on relations with France during the difficulties with the French minister, Citizen GENET, and the President's Neutrality Act. Now, the justices responded in August of 1793, just about a year after Hayburn. And this time they wrote as a group. And they wrote that the lines of separation drawn by the Constitution between the three departments of government, executive, legislative, and judicial, there being in certain respects checks on each other, and our being judges of a court in the last resort, are considerations which afford strong arguments against the propriety of our extrajudicially deciding the questions alluded to. And I think that was one of the most powerful statements that the court could have made. That was made in 1793. One of the things I like to argue or bring out in the book is that the court really established itself during this first decade. Now, just to finish, I want to briefly look at where did the court meet. In 1790 through 92, the court, the federal government had their capital, as I mentioned, in New York. And this building, the Royal Exchange or the Merchants Exchange building, was where the court first met on the second floor for those first 2 years. And this was in southern Manhattan in what is today the financial district. It no longer exists, this building, but nonetheless, this is where they met for those first 2 years. In 1792, the capital moves to Philadelphia. The court moves with them. And for 8 years, they had their home in Old City Hall, which is there on the corner. To the right, just to orient you, is the old State House, or what we know of as Independence Hall. And then to the left, that brick building behind the Supreme Court building, that's the American Philosophical Society. And here is the courtroom in that old City Hall building. You can visit this. Well, probably not today, but you were able to visit it during more normal times. In 1801, when the capital moved to Washington, the Supreme Court naturally moved with them, but they found out that they were homeless. There was no accommodation made for the Supreme Court for a courthouse. So the Supreme Court took a space in the basement of the Capitol where they stayed for about 60 years. This was the courtroom that was used by John Marshall. There were only 2 Chief Justices during this 60 years, John Marshall and then Roger Taney. And so in 1865, the court moved upstairs to the old Senate chamber. They were there for about 70 years, and the space in the basement became the law library, and that was the library again for about 60 some years. And again, the old Senate chamber. I believe all of these are open to the public at the Capitol when they are offering tours. And then in 1935, of course, they finally get their own building, the building that we know today, designed by Gilbert Cass and spearheaded by Chief Justice William Howard Taft, who I think most people know was also president from 1908 to 1912. So Taft had the luxury of not only being Chief Justice, but of having the ear, if you will, of Congress. Taft knew how the Congress worked. Taft knew how federal appropriations worked, and was able to get the funding for the building. And again, if you haven't visited this building, I would highly encourage it. It's just a beautiful, beautiful structure. And I guess with that, we will call it complete. And I'm happy to take questions or any comments or clarify things that you might have. So thank you.
Thank you, Jude. If anybody has any questions or anything or comments that they'd like to share, please use the questions box in the GoToWebinar dashboard and send them our way, and we'll be happy to look at them. All right, looks like we have some coming in. James Wilson was arrested. Can you discuss?
Yes, James Wilson, again, like John Rutledge, a very sad story. James Wilson was from Scotland, was a brilliant man. His brilliance was noted very early. He studied in Scotland, moved to Philadelphia where he studied law with John Dickinson, and then set out on his career as an attorney and as a political figure. And he also became swept up in the land speculation, Western lands, which at that time was Ohio, Indiana, Kentucky, Tennessee, etc. And throughout the 1770s, 1780s, and into the 1790s, his time on the court, he was beset by creditors. He was not a very good businessman. And he was even a worse investor in Western lands. Now, we know there were many, including George Washington, we know there were many famous founders who were involved in speculation. Washington was a little better at it, but there were many people, well-known and not known, who were involved in land speculation. So James Wilson, by the 1790s, and we've got a letter in our collection at Morristown from James Wilson where he's writing to a creditor asking for a higher valuation on his household furniture that he's selling to square away some debts. Wilson is being placed under arrest. There's a warrant for his arrest. He leaves Philadelphia, I believe, around 1797. He's on the run down to North Carolina. He stays at the home of fellow Justice James Iredell, and he was never captured. He was cornered in a tavern, I believe in 1798 it is, and he suffers a heart attack and dies. His wife, who was about 30 years younger than him, was left penniless. And Wilson was buried in a pauper's grave in North Carolina, and he stayed there till I believe it was 1905, roughly, when he was reinterred to Philadelphia, and he's buried very near Benjamin Franklin today. But whether he was actually arrested, I don't know that. I mean, I know there was, like I say, a warrant for his arrest probably more than once, but whether he was actually taken into custody, I guess he probably was in the 1780s. But again, he was plagued by that throughout most of his life. He just was not a good businessman. And again, it put him as a justice in a very bad compromising situation where these creditors could put pressure on him in terms of cases, etc. That wasn't as much of a concern at that point, but as we know today, it certainly is, and it certainly became a concern in the 19th century. So yes, Wilson had a very, sadly, colorful life.
All right, let's see here. Next one is great presentation. No questions, just wanted to say thank you for putting this on.
Well, thank you.
Visiting DC all these years, no idea of the court's different locations. I will certainly look for the courthouse earlier rooms when next there. Thank you.
Mm-hmm. Sure.
There's been a lot of focus around the size of the Supreme Court in the last several months. Is it clear how they arrived at the original 6? Why an even number instead of an odd to avoid a deadlocked court?
at the time, there were 3 circuits. It kind of went by how many circuits. They felt, okay, we could have 2 justices that, 6 justices, 3 circuits. That means 2 justices per circuit. That was not a rule. It was just a convenient way to do it. But in terms of a tie, the court really didn't release a finding or a judgment as a court. It was not as structured as today. It was each justice had an opinion that they presented and read, and it was often very difficult to determine which side they came down on. It was left up to the attorneys of either side to kind of keep a poll of, okay, well, I think Justice Iredell is going our way. It sounds like Justice Moore is going the other way, etc. It was called seriatim, where each justice gave their own opinion. But the court was much more, in these early years, you know, as I said, they were not only establishing boundaries, but they were also establishing themselves. They were still very new. They were still trying to figure out what a Supreme Court was. There weren't many Supreme Courts, even within the states. There may have been appellate courts, but nothing like a Supreme Court that looked at a constitution. Britain certainly didn't have a Supreme Court. Their highest appeals was the House of Lords. Britain did not get a Supreme Court until, oh gosh, maybe 5, 6, 7, 8 years ago. And but nonetheless, I'm not aware of any ties. But again, it's hard to parse out what the justices were trying to get at, because they don't, their determinations don't read like they do today. It's not a clear, this is where I stand and this is why. So it's a little bit murky, but that's just the way they did. And again, the number of justices has bounced around over the years. I think it's been 9 since about the 1860s, if I'm not mistaken. Of course, I'm sure most folks know Franklin Roosevelt tried to increase the number of justices on the court, but that did not work so well. And whatever's going to happen now, I couldn't say. But in the first decade, it was 6, mainly because of the number of circuits.
All right. What is your opinion on the possibility of increasing the number of justices on the court?
Well, again, I think the highest it ever was 11, and then it went back down to 9. I don't know. Currently it's such a hot potato. I would be afraid to even wade into that discussion right now. I think time will tell. But of course, as I said, 70, 80 years ago when FDR tried it, it did not go well. So that could be a bellwether. I don't know. But that is the most recent history we have to look at in terms of trying to change the number of justices.
Who again were the first 13 appointed to the Supreme Court?
Okie doke. So James Wilson, John Rutledge, William Cushing, Robert Harrison, John Blair, and James Iredell. And then in addition to those, they were the first. Then throughout the 1790s, there would be Thomas Johnson, William Paterson, Samuel Chase, Oliver Ellsworth. Those were Washington appointees. And then the Adams appointees were Alfred Moore and Bushrod Washington.
All right. We had a couple people ask if the slides are available. This is being recorded, so we will post it on our YouTube channel. But I don't know if it would be something where you would want to distribute your slides.
I'm happy to if you could help me do it. I don't
Sure.
know how to do that.
Okay. Yeah, we'll make sure that everybody gets a follow-up email with the information.
Sure.
Okay. Can you give a brief background of Samuel Chase? Thank you. Great presentation, by the way.
Oh, thank you. So the issue with Samuel Chase, when he was in the Continental Congress during the Revolution, during the 1770s, 1780s, he was at one point governor of Maryland, but he was also cornering the market on, I believe it was flour. And he was what we would today call a war profiteer. I mentioned that, well, not just myself, but others who have studied this, were why on earth George Washington nominated him to the court is still a bit of a mystery. I mean, yes, he did serve in the Continental Congress. He was governor of Maryland. He served in other posts and positions, but he was a bit of a slippery character in terms of business dealings. He was much if you look at James Wilson, who did not do well. On the opposite side of that, Samuel Chase did very well and made himself very wealthy. And in fact, he was so reviled and hated that Thomas Jefferson, when he became president in 1801, immediately tried to impeach Samuel Chase. But there was still enough Federalist support in the Senate to not convict Chase. So as I say, it's still something debated. You can find arguments on both sides as to whether or not Chase was a good choice. He seems to have been relatively objective as a judge, but nonetheless, his fortune was, I think most would agree, tainted at best. So that's his story. And he shouldn't be confused, by the way. He's sometimes confused with Salmon Chase, who was appointed Chief Justice by Lincoln. So there were two Justice Chases, one Samuel, one Salmon. It's a bit confusing.
How many of the early justices owned slaves?
Well, let me see. John Jay certainly did. John Rutledge, absolutely. Cushing did not. Harrison, I think, maybe had a handful. John Blair had a few. James Iredell, I don't think had any. So of the first six, I would say Jay, Rutledge, Harrison, and Blair. And then of the rest of the group, Patterson, Johnson. I don't know about Samuel Chase. I don't think he did. Alfred Moore did not. Oliver Ellsworth, no, he was very much against slavery. Bushrod Washington, certainly. Bushrod Washington actually was one of the founders of the, what was it called? The American, well, anyways, the group that tried to start the colony of Liberia, the notion that the slaves could be sent back to Africa. And I think Bushrod even served as their president briefly. But anyways, yeah, Bushrod certainly did. And of course, John Marshall, but he's past 1800, but of course he was also a slave owner. So I would say about half of them, 60%.
What was the major issue in the first 10 years?
I would say the establishment of the court as a separate entity, a separate but equal entity within the Constitution. And I would point to Hayburn's case. Again, it was not a technical case, but I would point to it. And then I would point to the 1792 Invalid Pensions Act. And then certainly, if you're looking for a specific case, I would guess I would say Chisholm versus Georgia, which dealt with the rights of an individual to sue a state. And, Georgia, again, this was 1794, I believe. But anyways, there was still, the Constitution was still only about 5 years old. Georgia was arguing very strongly that its sovereignty would be lessened by allowing a non-citizen to sue Georgia. This case sprang up over an inheritance and over an executor who lived in another state. And but anyways, the upshot is that the Supreme Court ruled for Chisholm, and it so rattled the states that I believe to this day it's one of the quickest turnarounds in terms of creating an amendment, the 11th Amendment. So the first 10 amendments are commonly referred to as the Bill of Rights. The 11th Amendment was specifically put in place to make sure that the court could not rule the way it ruled in Chisholm, which was against a state, in this case, the state of Georgia. The Supreme Court could not rule an amendment unconstitutional. And so here, I would say that was probably one of the biggest. And as I say, I think to this day, it might be one of the quickest turnarounds from the time an amendment was proposed to the time it was passed, because it really rattled the states, that decision.
Somebody commented, "Thank you, very enjoyable presentation."
Okay, thank you.
And that's everything that I have. Again, if anybody has any questions or comments, please submit them using the questions box. We'll be happy to address them or share your comments.
I want to thank everybody for signing on today and for listening to us. And as Andrew said, we will have this up on our YouTube channel. So you can go there and find a lot of good things, that some of the programs that Andrew not sponsors, but organizes and carries out are on there as well. So if you know someone perhaps that had signed up for this and wasn't able to take it today, then you can at least, they could hear the presentation and that. I want to thank you, Jude, very much for this. It was very interesting. And like I had told you when we weren't, out for everybody to hear, that, it was something that I really knew nothing about, even though I quite enjoy history. So I want to thank you for doing this for us.
Thank you very much. It was my pleasure.
Yeah, looks like another question came through, if you have some time.
Sure.
How did Ellsworth change the court?
Ellsworth was appointed Chief Justice by Washington, I believe in 1796, after 96, after the debacle with John Rutledge. And Ellsworth was, I would say, very much in line with John Jay in terms of being a kind of muscular defender of the Constitution, if you will, in terms of not being concerned about making bold presentations concerning, or decisions concerning the Constitution. I think where Ellsworth may have set a, I don't want to say a bad precedent, but not the best precedent. He was in 1798, I believe, 99. He was asked by President Adams to go to France to be in a kind of an ambassador at large to help negotiate an end to this quasi-war that I talked about that had been going on for 8 years. And Ellsworth became a diplomat rather than a jurist. And what I mean by that is that there were a number of cases, most of them involving shipping or privateering off the coast of the United States, that the Supreme Court during the late 1790s were adjudicating. And many of these cases dealt with whether the United States was actually at war with France. And some of them, the cases were decided that the privateering was allowable because the United States and France were at war. Now, when he went to France as a diplomat for President Adams, he went with a portfolio that said, no, we are not at war. We want to negotiate and end this quasi-war because it was so expensive. And but what's interesting is that at the same time that Ellsworth was in France trying to negotiate a peace, sticking with the line that there was no war, Bushrod Washington, who was at the time acting chief, if you will, because the Chief Justice Ellsworth was in France, a case was determined, a privateering case, and Bushrod was seeing this as the opportunity to spell out what war meant under the Constitution. Of course, the Constitution says that only Congress can declare war. But Bushrod reasoned that, well, Congress did not declare war with France. However, it was a war in all but name. So in practical purposes, for practical purposes, there was a war. So here you had Ellsworth in France trying to argue that there was no war, but Bushrod in the United States arguing, yes, it was war. And it just created a lot of problems, as you might imagine. For President Adams, I think it was one of the reasons he ultimately lost his reelection bid. And so I think, today we don't have the Chief Justice going on these kind of ad hoc diplomatic missions. And in fact, I think it was probably the last time that a chief, well, no, I take that back. I think during World War II, Justice Jackson, but he wasn't chief, but Justice Jackson, I think, presided over the Nuremberg trials. But anyways, that was a little bit different, I suppose. But I don't think there was a chief after Ellsworth. So I would say he changed the court. He didn't so much change it as, again, as I said, some of his decisions were very much in line with John Jay, but I think he kind of set the precedent that there will be no more chief justices serving these kind of extra diplomatic duties.
All right. Were there any Quakers on the early court?
No. No. In fact, that could be one of the reasons that, although he wasn't a practicing Quaker, John Dickinson, who was probably one of the most famous lawyers in the country at the time, of course, he also had the strike against him that many felt a strike against him that he did not sign the Declaration. But he was also a Quaker by upbringing, although, as I say, he did not practice. So there could have been, you know, a little bit of Quaker bias, I guess.
All right, well, it looks like that is all the questions and comments that I have.
Wonderful, wonderful. All right, very good.
Yes, well, again, thank you everybody for attending. Thank you, Dr. Pfister, for this fantastic presentation, and Cindy for the great work you do in putting these programs together. As we said, this will be available for viewing later, so please look out for an email that'll include that link. We hope you join us for our upcoming programming, and everybody be safe, be well, and hopefully we'll see you soon.
Thank you very much.